No, you're creating difficulty where there is not difficulty. And you're not listening to what I'm saying. Court does call the case of the estate of Earl Samuels II versus Jonathan Samuels.
Good afternoon, Your Honor.
Afternoon. Your names, please.
Jonathan Samuels.
All right.
Steve Magus, Your Honor, attorney for the personal representative of the estate of Earl Samuels, Tim Flynn.
Okay. Couple of things, and the reason that the court set this hearing. We have checks in place to try to make sure that documents aren't filed. I'll say in violation. I'm not saying that using the word that it was intentional necessarily. All of which includes the court officer, all of which seem to have not taken place. But the question for the court is frankly, I don't know that this writ should have issued in the fashion that it did. Maybe for not, but ultimately, but it should not. First question I have is the documents we had indicated that the writ was executed.
Yes, Your Honor.
Okay.
Without any notice.
Well, there would have had to have been notice because there should have been 72 hours notice.
They put a notice on the house, but he knew that at the time I wasn't staying there. He knew where I was. He didn't email me or
Who knew?
Attorney Marcus.
Well, all of the orders of eviction which I sign and send out, and I'm the one that does it, there's a 72-hour posting. So it's posted, it won't be executed for 72 hours. Are you saying that didn't happen?
I imagine, no, they put a notice on the door when I saw it, when I went there afterwards, that the notice on the door was dated more than 72 hours before the action that they took. So they did that, but the point is, Attorney Magus has been in communication with me about a lot of things. Deliberately didn't tell me they were doing this. He deliberately didn't tell me they were towing my cars. It's representative of how everything has gone and his lack of respect for my devisee ownership right, and the fact that I told him from the first moment I talked to him, now nearly several months ago, that buying the farm was the most important thing to me, and he's done things which have very much hurt me and my ability to follow through on that. So this is just one of, he also locked me out of the house where I was staying at the time on June 30th, my parents' house in Farmington Hills, without notice. So he has a pattern of doing things just that are easy for him. And then he tries to say I wasn't staying there all the time, even when, as he saw, my things were there, my food, my computers, my documents, I mean, so and now they're saying that I never lived at the farm. I did live at the farm in the past. I mean,
There's a big story here that we could take up the rest of your afternoon, and then some with regard to the administration of Jonathan's parents' guardianship and conservatorship, and now their probate estate. I'll try to keep it on the main points that relate to this case. The property that we're talking about here has been approved for sale by the Oakland County Probate Court.
Got it.
Before the probate estate of Earl Samuels was involved, a judgment was issued that advised Jonathan, I think it was the end of 2023, that any personal property that he wanted to remove from the property, he needed to remove by, I think, the 12th of December, 2023. We had several of these judgments with regard to estates and properties, okay? And I applied for orders of eviction on all of them, just to simplify the contingency that Jonathan has a pattern of anytime we try to sell a house, he says he lives there and he moves in. So I learned thereafter about there's potentially a court rule that says it has to be 56 days.
Yeah.
It wasn't that intentional. It wouldn't be the first time I've learned in real time about a court rule. But the reality is Jonathan doesn't live there, and he's using this as an opportunity to effectively appeal the probate court's decision to allow the sale.
Which was based on misrepresentations, many of which by Attorney Magnus.
All right,
I believe,
so I'll let you talk, sir, but I'm not
I'm sorry, Your Honor.
going to have parties interrupting. Let me just say this, I'm not going to get into anything that the probate court does. If I wanted to be a probate court judge, I would have done it. So I'm not going to do that. All right. The issue that I have in this case, and like I said, there are a number of checks in our system, all which failed, is that there would have needed to be a hearing prior to the issuance of the writ. It becomes a little bit more concerning based upon the documentation that I received today and reviewed, that the defendant does not reside at that address. That's what I received today from, I think, the individual who is a conservator of the estate or the personal representative, which maybe means that the issue is moot, or maybe not, because, sir, you're claiming you reside there.
I'm claiming that I resided there in the past, that there's things of mine there, and that they still need to go through some process because I have rights. Because especially now that there is an estate and I'm a 50% advisee, that they can't just, without any notice, decide to try to have something enforced that's actually a totally separate action that nearly 2 years ago. It's obviously no longer the conservatorship, and I didn't have any ownership right then. So it's, the law is actually that ownership passes at the time of death. It's just subject to administration, and then it gets backdated, sort of. So I have a legal interest that I did not have in the farm almost 2 years ago. And in fact, I told, as I say, Attorney Magnus how important it was. And he refers to me not moving things out. Well, what I told them nearly 2 years ago was I was determined that the farm wouldn't leave the family. So Dad didn't want it to leave. He had testamentary capacity. All of this has taken place because people don't respect even the proper procedure.
Sir, I'm just gonna stop you, because you're getting into issues of which this court doesn't have jurisdiction over.
Right, but it did have and there's actually some question of whether it even has the authority to evict someone in a situation like this. Some things that I was studying today, and I actually filed something additional with the court because of my ownership interest as an advisee, that it's not even necessarily subject to the same landlord-tenant eviction procedure as Attorney Magnus had enforced inappropriately. So it's complicated, and Attorney Magnus and now my sister's attorney want it to be simple. And it's representative, as I was starting, of many things that have happened over the past 4 years. Because my parents were clear on what they wanted. My dad was clear on what he wanted for the future. And for the farm to be sold like this is horrific. And the fact that...
But sir, just stop for a moment. the sale of the farm, as you're indicating, again, is not something that is
Right.
within my jurisdiction.
That was my next sentence, but your signing this order was an essential step in them selling the farm. So,
And it may very well be, but what they do with the property after an eviction, I'm not part of it. I don't know. On the numerous cases I've had today, there are eviction orders that are issued. What then the owner or the person in charge or with authority over that property does, I don't deal with.
of course, Your Honor, I'm just asking for you not to issue an order of eviction in this case, especially because there's multiple reasons not to issue it. Both the fact that, as you say, they didn't follow the regular rules the way they're supposed to, initiating a new proceeding if they were going to argue that eviction was the
Well, they wouldn't be required to issue a new proceeding. There would need to be a hearing prior to the issuance. But then the information that I've subsequently received may have the ultimate result of that be moot. Because the real issue is at the point, there's a time limit from the point of the judgment to the issuance of the writ, and then how long the writ then has to be executed. There are 256-day periods. Here, the first one, in terms of having a hearing, wasn't complied with. The question becomes, at least in my mind, is do I order you restored to the premises or do I not order you restored?
I would say it's simpler than that to just vacate or stay your eviction order because there's.
Can I just say this? By what you're telling me, and I don't know this for sure, but certainly the information that I received was that you were not residing at the property.
Not.
Things you're saying to me right now lead me to believe that you weren't residing at the property and that there really hasn't been any harm by the execution, because you keep talking about something that has occurred as though it hasn't occurred.
No, they definitely caused harm. They already towed my vehicles. They broke into the house. They didn't give me any notice that I needed to work to remove, because they're actually, even though the house, I mean, there's things of significant value there that Attorney Magnus is not aware of.
If it's helpful, Your Honor, with regard to the substance past the procedure, he can have everything in the house. It's a hoarder house. You can't even open the door. It's actually dangerous, which we're a little bit worried about. But if he's willing to waive liability, he can go in and take whatever he wants. What we're trying to avoid is him getting back in there, claiming he lives there, and stopping the pending sale.
Okay, so let me just say this: although the eviction was executed, there was property that was not removed from the premises as of yet.
The only property that was removed from the premises is 2 derelict vehicles that were towed and are available for Jonathan to pick up. They were
okay, but those were on the outside. Those were on the premises, but not inside the house.
Yes.
But as far as things in the house, nothing was removed.
Nothing was removed from the property.
Okay, that's
not true.
makes it
They
easier for me.
moved things out on the front yard. They took some things. I mean, I wasn't there, but it looks like they took some things away. Because they scattered stuff on the lawn and out by the curb.
Here's what I'm going to order at this point to try to correct the 56-day issue, as well as to try to address whether or not then there's sort of this clear path to the estate doing what it wants to do. I'm going to set a hearing. So while it's after the fact, the very fact that things have not been removed is fine. My determination will be whether to allow the execution of the writ to stand. And in that respect, the property inside, you can let them in or not, if that's the way I rule. Or that you would at least for a time period be restored possession of the premises subject to the hearing and then the court's issuing of a new order of eviction. And that's the best I can do to kind of remedy the circumstance. Quite frankly, it's a little bit easier than I thought because stuff hasn't been moved. So it's easier in that respect. It's also maybe easier in a certain respect. I don't think you were residing there. So it's not like I took. Sir, please.
I'm sorry, Your Honor.
It is not as though there was a, for lack of a better term, a household that then is completely taken out, and this is a different scenario. So we will have the hearing, and I will either allow the execution to stand or put it back in. That's how I'm going to handle this. And so, when's my next
The time issue, though, is
I'm sorry, sir.
that I would have, if he would have followed things, I would have had more time to deal with. There's things there that would take me some time to move.
But sir, okay, let's just go with your hypothetical. Had that happened, they would have requested a hearing because it's afterwards. Let's say at that end of that hearing, I permit the issuance of the writ. Okay, just hypothetically, let's say we had gone through that whole process. And let's say they brought their $15, they brought the writ or the order of eviction in, I sign it that day. They get the officer to go out there, post it. You're going to have the same time frame. You're going to have those 72 hours prior to then the execution of the writ. So in terms of your argument regarding time, it's not an argument for the court.
Wouldn't there have been time before the hearing that I would have been notified of the upcoming hearing?
Right.
So that's the most significant time. Because
Are you listening to anything I'm saying?
I definitely am. You said that the order of the writ would be 72 hours, but I'm talking about before that, before you would potentially issue the order, the time between being notified of the hearing and actually having the hearing. And I don't know.
Okay, so here's what I'm going to do. Listen real carefully. I think counsel gets what I do. I'm going to set a hearing. Normally what the hearing would have been, had it occurred in its order, would have been a determination as to issue the writ or not. I will set that hearing, although it's seemingly after the fact, there isn't much harm or any harm because I don't have a household that's displaced. What I really have is a circumstance where they've taken possession of the premises. Things have not been removed. And then I will make that determination as to whether or not that writ will stand or it will not stand. You follow that?
Yes, Your Honor. I just thought that there's requirements of notice before such a hearing.
I am about to set a date and that will be your notice.
And what would the date have been if they just started prep?
Sir, yeah, okay.
I'm sorry.
I'll give that to you. Hold on one moment. What did I say, 16? Okay, so here's what I'm gonna do. I'm gonna set it for the 16th. Okay, in person at 9 a.m. Now, we're on the 5th. So that gives you now, from the court's final ruling, 11 days. So your question is whether or not that in some way penalizes you. Actually, you benefit from it. Because had they filed the motion or the request for hearing prior to, had they mailed it to you, they could have had a hearing in 9 days. If they had personally served you, they could have had a hearing in 7 days. Here that's the notice you would have gotten. Here you're getting 11 days.
Okay, Your Honor, but would that have been a hearing based on the previous filings? Because that's my basic contention
Previous filings of what?
that led to your judgment in December of 23.
I don't know what that means.
They're attempting to continue something that isn't. So I'm not sure how the procedure would work if they didn't have the December of 23 record and your.
You are truly not following this, are you?
I'm sorry, Your Honor, I'm just thinking.
No, you're creating difficulty where there is not difficulty. And you're not listening to what I'm saying. Because what I'm telling you is that on the 16th, I will make a determination as to whether or not the writ stands, or whether or not that writ is then the execution thereof is squashed and you're restored possession of the premises.
Okay, thank you, Your Honor.
That is the same decision, quite frankly, that had they filed the 56 days and had they filed for the hearing, that is basically the same determination that I would have been making. Could they have the writ, or do they not get the writ for whatever various reasons, may have to do something else?
What's the reference to 56 days? That's what I don't understand.
There are two 56-day periods in landlord-tenant law. First is that a judgment must issue within 56 days of its rendering. Has to be signed. The second is that a writ, well, actually, that first one isn't really necessarily a 56-day. After the judgment, the writ of restitution or order of eviction cannot issue 56 days, more than 56 days after, without a hearing. And then once that issues, that the second 56 days is that writ must then be executed within 56 days of.
Oh, it's okay. That's what I didn't understand. Okay. I thought it was a after. It's a within. Okay.
What's a within?
The 56 days that you refer to are periods within which something must occur. I thought they were periods after.
Okay, so that I'm not going to sit here and go into some huge legal argument with you.
Okay.
It's the 56 days where things can happen automatically without court intervention. Let's do it that way.
Thank you.
All right. So while that happened in this case, I'm in the writ was not executed in its traditional sense because things were not removed from the premises. And I will take counsel's representation as not for the court. That has not occurred. So then the question becomes, really, just to break it down to you, make it easy. I'm going to have the hearing on the 16th for a determination as to whether or not I allow the order of eviction to stand or whether or not I vacate.
Thank you, Your Honor.
So I will set that hearing September 16th, 2025 at 9 a.m. That will be an in-person hearing. Provide to the court whatever you wish the court to review prior to that time. And I will also review what I need to at that hearing and make my determination. Thank you,
Things
Your
will still be here, or will eventually you be in Saline?
Pardon?
Things are always going to be here, or will you eventually be in Saline?
It will always be where I am. So I am here. So it will be here. I will let you know that on the 16th, it won't be in my courtroom, courtroom C, it'll be in courtroom A on that date. Because it'll be
You're always here. Some things are out of the 14A4 in Saline.
14A4 hasn't been open for almost a year now, sir.
Okay, I'm unaware of everything. I'm sorry.
Okay.
Should I prepare an order, Your Honor, or will the court Thank you.
we're good. We'll have to hear. All right, thank you.
Thank you.
Hey, thanks for watching. Please do let us know in the comments what you thought of this video. If you'd like to support what we do here, the best way to do it is to pick up some of our merch. You can find it at courtroomfiles.com.